Hello, everyone, and welcome to Uncivil Law. And for today's story, we catch up a little bit on Nick Rekieta as his case is coming to a close. So, as you will recall, Nick Rekieta previously entered a plea deal relating to his charges, and we have been waiting for the sentencing, which I believe is still scheduled for tomorrow, but we have the proposed sentence by both parties. So, we're going to go ahead and cover that. So, we'll just go ahead and get started. We turn our attention once again to the case of State of Minnesota versus Nicholas Rekieta in the state of Minnesota, county of Candy, Ohio, wherein we have a sentencing memorandum from relating to the defendant. Mr. Rekieta stands convicted of possession of 10 grams or more of narcotic drug other than heroin or fentanyl or drugs in third degree. He got a plea deal. Defendant entered a guilty plea. As part of the guilty plea, defendant received a statutory stay of adjudication. The remaining terms of the sentence are at the court's discretion. A pre-sentence investigation report was ordered and been filed with the court. So as we sort of discussed before, the actual adjudication of his plea would be deferred. So he's been found guilty, or he's entered a guilty plea, but he isn't actually guilty at this time, or he wouldn't be guilty at this time, because the actual judgment of guilt is deferred. And it's deferred if he complies with all the conditions of the probation. And this is not an unknown concept in law. This is a deferral, very typical in first-time drug cases, where you kind of get this kind of thing, a bit unusual for higher degree felonies, because this was a second-degree felony, but they pled it down. So a little bit unusual for felonies, but Minnesota rolls that way, so that's the way they go with that. Anyways, a pre-sentencing investigation report was ordered and has been filed with the court. The report notes the defendant falls into the low-risk category for general recidivism in comparison with other individuals with similar characteristics. Defendant will need to demonstrate positive pro-social adjustment in the following areas in order to reduce the potential for recidivism: leisure, recreation, alcohol, drugs. I mean, compared to all drug users, I think that's fair, to be honest. I mean, Nick has his problems, but compared to all drug users, he has better indicia working for him than most people. He has support. He has parents who apparently still support him. He has a wife who loves him. He has children. He has family. He has been successful in the past. He has the potential for earning money due to his training and education. So he certainly has more factors going in his favor than the typical drug user. So compared to most, he has a chance, which I think is fair. The PSIR notes that the conditions, programming, and interventions contained in the recommendation section of this report are meant to aid the subject in successfully addressing those areas while promoting the public safety. Additionally, the legislature has exclusive authority to define crimes and offenses and the range of sentences or punishments for the violation. No other or different sentence or punishment shall be imposed for the commission of crime than is authorized by law. I mean, do we really need to say that out loud? But apparently we did. The report recommends defendants serve 30 days in jail, credit for 2 days served. And so that's interesting, is that the pre-sentence report recommends jail time, which we didn't really expect. Even 30 days, we didn't really expect for a first-time offense. But they're recommending 30 days jail time. Now, presumably, if he gets jail time, it would be served like he would have to show up on the weekends, kind of thing. Probably was how that would go down. Probably wouldn't be continuous. It would probably be, show up on the weekends and do 2 days at a time for 15 weeks or something like that. But interesting, the pre-sentence report recommends jail time. Didn't see that one coming. So that's interesting. However, the recommendation is not borne out by any specific facts in the report. It seems more than boilerplate language is inserted in the report rather than considered and reasoned recommendation of a trained probation agent. You wish. Indeed, it's hard to conceive how this recommendation is meant to aid the subject in successfully addressing those areas while promoting public safety. Jail should be sanctioned as a violation of probation condition and as a workaround by the state for stay of adjudication defendant received. I'm sure the language in the report was fairly bureaucratic because they're bureaucratic. So it was very paint by numbers because that's the way bureaucracies roll. So I agree that the pre-sentence report did not contain super special, interesting language about Nick and how he's a special boy. Probably was very banal, basic, and dry. I'm sorry that the language was a little dry for your taste, but yeah, I don't think that they necessarily were doing anything other than what they do typically. So, but nice to try to reach, I guess. The length of the probation appears to be a similar problem. The recommendation relates to a term of 5 years. Wow. I mean, that's a lot, right? Technically, his probation can be up to the length of the possible sentence. But, we were thinking maybe 1 year, maybe 2. But the pre-sentence report recommends 5. 5 is a long time, man. 5 is a long time to have to be in probation and have to do drug testing and urine testing and alcohol testing and have the police, show up and do searches and all. That's a long time to keep your nose clean, just saying. And if you violate that probation, remember you've already pled guilty. Remember that part where he's already pled guilty? So that means that if he violates probation, that guilty can get entered, and now we can sentence him for the crime. So that's a lot of pressure. You screw up one time, and they can yank the deferred. They enter the guilty plea. You've already pled guilty, and now they get to sentence you based on the crime, which might include exciting prison time. Holy shit. 5 years is a long time, man. So the defense is not really happy with the 5 years proposal. They prefer less. However, no facts in the report support the recommended length of probation. Instead, the recommendation appears wholly conclusory. Similarly, it's hard to conceive how the recommendation is meant to aid the subject in successfully addressing those areas while promoting public safety. Well, hopefully it keeps his nose cleaner longer would be nice. Additionally, the court may defer further proceedings and place the person on probation upon such reasonable conditions as it may require and for a period not to exceed maximum sentence provided by the violation. Right. So they can put you on probation up to the entire length of the sentence if they want. However, in this case, the recommended deferral period is 21 months. So they think the recommendation is 21 months. They think it's about 2 years, which sounds more right to my mind. It would both defy logic and common sense to defer adjudication for 21 months while simultaneously placing defendant on a probation for 60 months. Well, we can fix that by, keeping the deferral period open because we can do it. We're allowed. The PSIR recommends defendant complete 80 hours of community service work. However, again, the recommendation is wholly conclusory. I mean, of all the things to complain about, the 80 hours of community service, really? I mean, I'd probably go the other way if I were the defense on this one. I would be my gut instinct. I'd probably be saying, we're willing to do more community service in exchange for less jail or less probation. But 80 hours of community service is too much? Seriously? Okay. All right. Seems like a slightly strange choice to me tactically, but you do you. However, this recommendation is wholly conclusory. The recommendation links to no facts that support recommendation. Similarly, it's hard to conceive how this recommendation is meant to aid the subject in successfully addressing those areas. As long as we're talking about conclusory, I have to say that your memo is conclusory. So you think the government's being conclusory, you also are being pretty conclusory. You're not actually making an argument. You're not actually saying, why these numbers are wildly out of pocket, based on the special reasons. You're just saying that they're wrong because the government's conclusory. I don't think that's necessarily going to persuade the judge at the end of the day. Just, again, strategically, I'm not sure it's the wisest course of action, but okay. As the letter submitted with the sentencing memorandum demonstrate, defendant is a very active member of his community. He has continued to be active and involved in his church during the pendency of these charges. Defendant is currently restricted from the practice of law despite having an attorney registry number. As the report notes, defendant's business allowed him to directly donate hundreds of thousands of dollars to charity, and indirectly $1 million plus by encouraging my audience. What? He directly donated hundreds of thousands to charity and millions by encouraging his audience? What self-serving garbage is that? He's done good works, people. He's done good works because he's encouraged others to donate to charity. Millions of dollars to charity. Where are we pulling that number out of? Our ass? Also, hundreds of thousands of dollars to charity? Do you mean by like buying paintings and stuff at art auctions? I mean, I don't know, man. And also hundreds of thousands of dollars? I doubt literally every sentence of that. I doubt literally every single word. Hundreds of thousands of dollars, directly donate hundreds of thousands of dollars to charity. And indirectly encourage his audience to donate millions to charity. He's a philanthropist, people. He's a philanthropist doing good works. Okay. In this case, Ohio County Community Corrections Center has failed to deliver to this court an adequate pre-sentence investigation report. Very little in the PSIR reflects anything that would be considered a reasoned conclusion that aids this court in properly sentencing the defendant. Accordingly, the court should stay adjudication and place defendant on a probation period of 12 months, which also is a number we pulled directly off our ass. There's a footnote. Let's see if there's a footnote that matters. There are no footnotes that matter. Great. Signed, defendant. All right, fantastic. All right, so let's read some letters in support relating to this. Here is a letter in support. Dear Judge Wenzel, I've known Nick Rekieta professionally and personally since 2022. Nick created an entirely new type of entertainment covering legal battles on YouTube that was wildly successful. Oh, bullshit. That he created it? He created the content? I object to that. My channel goes as far back as Nick's does. And if we want to go to the OG, it's got to be Lawful Masses. It's got to be Leonard French, who was the first. But yeah, he created it. Bullshit. He created. He might have gotten it. He might have popularized it. He might have been at times the most successful. But he created it. Bullshit. I object. His commitment to his work and love of law drove him to be one of the most successful law channels on YouTube, drawing hundreds of thousands of people to engage in legal discussions. Is that what people were doing? Engaging in legal discussions on his chat? I'm not sure about that. I've seen his chat. I'm not sure legal discussions is how I'd characterize it. But, you know, okay. All right. Let's see. Nick's unique style of covering trial from gavel to gavel with humor, legal analysis, and irreverence led to multiple law channels gaining notoriety and popularity. Holy shit, he's literally taking credit for me. He's literally doing I created you. Holy shit. Holy shit. I created you. I created you. Wow. Wow. Epic. Is it too late for me to write a letter? Does the government need me to write a letter? I mean, he's not supposed to be sentenced till tomorrow, right? Is it too late for me to write a letter? This is some bullshit. Call me if you need me to write a letter, government. I'm here. Oh, Lord. The law became approachable for the average person through Nick's invention. I am going to be sick. Several channels became successful because of his model. An entire community known as LawTube grew out of Nick's influence. Okay, so not only is he taking credit for it, he's also taking credit for the term LawTube, a term that he repeatedly rejected and wanted nothing to do with. Outstanding. This led to many people becoming interested in law, going to law school, becoming lawyers, making lifelong friends with who shared interests in legal battles, and changed the trajectory of many lives for the better, including mine. My channel was positively impacted by Nick's unique approach to online entertainment and his direct advice and help. Like the vast majority of lawyers, Nick struggled with substance abuse. I don't think this is the vast majority of lawyers. I do agree that lawyers have a higher than normal rate, but I'm not sure it's the majority of lawyers. And I'm also not sure it's the vast majority of lawyers who struggle with substance abuse. But, maybe I'm off on that one. This is a well-known and studied problem for the legal profession. It's so widespread that every bar association has programming lawyers for substance abuse problems. Well, maybe Nick should have taken advantage of one of those programs. Maybe that would have been nice. The stress of quickly attaining fame and fortune is often a catalyst for substance abuse that's also widely acknowledged. Yeah, but he came from money, though. So it wasn't the money. Nick's meteoric rise to success no doubt played a role in his mistakes. We're doing affluenza. We're doing because I'm special because I'm successful. That's neat. That's an interesting angle. Nick acknowledged he broke the law. I'm not really sure that that's even necessarily true. He pled guilty, but given some of the things he said online, even since then, I'm not really sure, strictly speaking, he can be said to have acknowledged it. But, Nick acknowledged that he broke the laws, taking responsibility for it by pleading guilty to possession. The community and his family would not be served by his incarceration, but be served by his rehabilitation and his ability to get back the job he loves, explaining the law to his audience while entertaining them and supporting his family. In the years I've known Nick, I've known him to be generous with his time and helpful to anyone who wanted to know how to be successful on YouTube. He has a genuine desire to help others and has helped me on many occasions, whether it was to give me advice about my channel or just be a friend and listen when I need someone to talk to. Nick is loyal, kind, empathetic, smart, and passionate about his work. He is a good friend, and good friends are rare. Okay? I've also witnessed Nick's interaction with his children and know they love him deeply and they share a loving, light-hearted banter that only loved children have with their parent. I will give him that much. I visited him at his house, and I saw him be very good to his children when I visited them. So, at least at the time I visited him, he was a good father, and he had a good family, and seemed to be working relatively well. So, that I will give him that much. That much is true. It is unmistakable that they love him and he loved them. Being a present father is important to Nick. Nick is also the main caregiver to his children, responsible for all their transportation to school events and classes. His children would not be served by a separation from their father, and the state should not take a father from their children unless he's a danger to society as the last option. Nick Rekieta is only capable of being a danger to himself, and I believe he'll recover and make better choices. I'm not sure about that either, but okay. This is Nick's first offense against the law. I believe he can recover, and the community should invest him and help him doing that. Everyone deserves a second chance. Many other people have completed diversionary programs and recovered their lives. It's my belief that Nick can recover his life and thrive after this unfortunate episode, in which I remain hopeful as a temporary setback in an otherwise amazing career and future. I hope this court sees the man I know and not the one gossiped about for chief laps or the persona fighting back against the gossip publicly. Okay, that sentence is the most telling sentence ever. So even this person, Megan Fox, even she subtly acknowledges that in his public statements, since he's pled guilty, has been less than, let's say, fully accepting of his criminal responsibility. Even she has to admit that much, right? But it's not him, Your Honor. It's the persona. It's the persona that's gone online and said all kinds of things that might be viewed as not accepting responsibility. It's just the persona, Your Honor, really him, really the person. He fully accepts responsibility in every way. He has done nothing but accept responsibility in every way. It's just that unfortunate persona online that has gone forward and said things that could be potentially viewed as not fully accepting responsibility in the deepest possible sense. It's the unfortunate persona. I like that even she has to acknowledge that some of the statements online have been less than fully. That's fun and exciting. I hope this court sees the man I know and not the one gossiped about for cheap laughs or the persona fighting back against the gossip. The Nick I know is a man who loves his family, helps those around him, makes mistakes, and then inspires others to be good humans. Nick is also deeply remorseful of any harm or pain he's caused to children and family. He may not discuss it publicly, but privately, he's devastated. Okay, sure. Many times, Nick used his platform to raise money for audience members in need by advertising their GoFundMe accounts. Nightly, is that what he talks about for the charity? Is that what he's doing? Is that the charity he's raised hundreds of thousands of dollars for? Is he referring to GoFundMe's that he took notice of, and so that's the charity he's raised millions and millions of dollars for? Interesting. Okay. All right. I mean, that's a take, I suppose. All right. Nightly, he would talk to them about their struggles, including thoughts of self-harm, and he always encouraged them to find something to smile about and try again. I've heard from many individuals who told me Nick Rekieta saved my life after reaching out to Nick in a dark time and finding someone who cared to respond. Incidentally, and not for nothing, when I tried to reach out to Nick, back when we were still on speaking terms, but when I tried to reach out to Nick, I found him very, very hard to reach. So, just saying. I pray this court will honor the plea agreement in this case and refer Nick Rekieta to probation. Sincerely, Megan Fox, author/journalist, also Baldo Washer. All right, what else do we have in terms of letters? Your Honor, I'm writing today to put in some good words for Nick and Kayla. Oftentimes, in such situations such as this, the bad is amplified and the good goes under the radar. First and foremost, I want to sing their praises as parents. As been evident throughout this entire time and before, the kids have been thriving. They're healthy, smart, engaged, talented, polite, active, and participatory in church and other activities. Again, this was true, at least at the time I saw him and his family. So I have no reason to doubt this much is true. You know, for his many, many sins, I have seen Nick be a good father, personally. And I will give him that credit. You know, I can't necessarily speak to what happened when I wasn't there, but I'll speak to what I saw. And I saw him be a good, caring, loving father who took care of his children, took care of their activities, drove them places, and all the rest of it. So I will give him that much. He deserves that much because it's true, at least from what I observed. Christian, who goes full-time to CCS, is in his junior and straight A student and a member of the National Honor Society. He also participates in drama, band, and debate. Avery and Sylvia go to CCS part-time and are also straight A students. They're also in drama as well as band and or choir. Audrey and Cecilia recently started taking Spanish classes at CCS. Except for Christian, the others are all homeschooled to some degree and advancing well. Christian was homeschooled until he was accepted into CCS for his sophomore year. Avery also plays both JV and varsity soccer. While he's the smallest player on the team, he also has one of the biggest hearts and always gives his best. Aww. All the kids take piano and violin, while the girls also take dance lessons. Sylvia takes 4 disciplines, Audrey 3, and Cecilia 2. These are extracurricular. While all these activities, both in and out of school, Nick and Kayla provide yeoman's work, getting them to and from school, sports, and activities. He does live in the middle of ass nowhere. And so I have no problem believing that he has to drive a lot, because he lives in the middle of ass nowhere and things getting to places probably takes a long time. So he probably spends a lot of time in the car. I believe that. Plus, with the 5 kids, getting them to their various activities. Probably is a lot. One wonders where Kayla is apparently in all this picture, by the way, because why is Nick always the one apparently doing all the driving and stuff? But I digress. All the kids and piano. Okay, we read that part. There were times where he did a lot of driving while they're separated from the kids, and we putting in 100+ miles someday. Every time we heard Krista Barber speak of the kids, she marveled at their intelligence, their talent, and engagement and politeness. All the kids are loving and respectful and cognizant of the feeling of others. Again, that matches what I observed. Their kids' ability in school and as they progress through a homeschool curriculum is a testament to Kayla's dedication and involvement in their growth. Nick and Kayla also have helped family members. When they've been asked to loan them money, they readily did so. I should correct myself. They didn't actually loan them money, they gave it to them. Then you're not speaking contemporaneously. Why didn't you just edit the letter? They loaned it. No, what I meant is they gifted it. Why didn't you just edit it? Do you not know that you can edit the written word? I'm confused. They never asked for repayment. They've always been there for Kayla's siblings and their families as they navigated through tough patches in their lives. They've treated Dan and Sherry to trips in Hawaii and Florida, as well as provide support during other family trips. During family camp at Lake Beauty Bible Camp, Nick and Kayla rent one of the large dormitory-style cabins and invite the entire family to stay. A couple years ago, also mistyped, when CCS was short of money and needed parents to be responsible to provide costumes for kids in the school play, Nick and Kayla anonymously stepped up and provided the necessary funds so no one had to pay. Well, that's nice. In addition, Nick and Kayla are regular supporters of Make-A-Wish Minnesota and the Minnesota Zoo in the Apple Valley. They've been active in their church community. The kids go Wednesday night activities at New London Faith Covenant Church every week. Christian and Avery go to Bible study Sunday evenings. They've also participated in other church-related activities throughout the year. They participate in overnight weekend Christian-themed outings, and Christian has gone to mission trips both in and out of the country. When Nick decided to go to law school, he had to drive to William Mitchell twice a week. He'd drive to class on Mondays, drive to our house to spend the night, drive to class on Tuesday, and then drive back to Spicer. He repeated the same drive for Thursday class. All this while Kayla supported him by holding down the fort at home with kids. Their dedication to getting him through school was impressive. It made us proud when he passed the bar on his first attempt and was subsequently sworn in. Once, Nick did a short video on his YouTube channel. He responded to a question where he's asked what his best moment as a lawyer was. He talked about how a woman he knew was involved in a custody battle with her ex-husband. Many times the child's weekends were with the dad. He'd come home with bruises. Other lawyers he had tried to sever the father's custody and failed. Nick was able to get it done and get the child out of the hostile environment. Okay. That's the son I know. That's the daughter-in-law I know. Regardless of their personal situation, they look out for others, their kids, their family, their friends, and that divorced mother who just wants a good life for their son. Sincerely, Robert Rekieta. Well, that's nice from Dad. I appreciate that. All right, and then we have a letter from Kayla, which I believe is our last letter for the day. Dear Judge Wenzel, I'm writing today regarding Nicholas Rekieta from case number 34CR24341. Interesting referring to him by full name, incidentally, rather than saying my husband or something, but I digress. I know there's a lot of information out there due to his internet presence, so I thought it might be beneficial to hear from someone who actually knows the man and not just the character from the show. Nicholas has been my best friend, life partner, and husband for the past 20 years. He's the father to our 5 amazing children. He is and has been the kind of man who will stop what he's working on personally to help the people around him who are struggling. When our nanny quit suddenly in the middle of our school year, he became one of the main drivers getting the kids to and from where they need to go for all their activities. Also, incidentally, why Kayla isn't doing this also a little bit unclear, but I digress. The kids take a mix of homeschool classes and classes at CCS. They all take violin and piano lessons. Our 5 boys are in speech. 2 kids play soccer. Our girls take dance classes. And all 5 kids are involved in church activities twice a week. Not counting extra trips to the doctor and dentist appointments, we leave our house to drive the kids to class and activities 4 to 12 times a day, depending on the day. I believe that. I believe that. A lot of driving. I believe it. There are even days that two drivers are necessary at the same time to bring kids to different places. Nicholas has been my rock, helping give our kids all the opportunities they can have. I could not raise our kids without the same diligence without him. In addition to him helping me with the endless driving, he's our main chef. He cooks almost all our meals, including the 11 p.m. request from our 17-year-old. It's fun to watch his skills and creativity. So Nick does the vast majority of the driving. Nick does the cooking. Again, what does Kayla do in this relationship? Unclear. Unclear. But Nick is a good person. At least he's a good father. I'll give him that much, man. He's a good father. This accords with my own understanding. He is, to the best of my understanding, and based on my own personal observations, the person who is the most present parent in this relationship. He is the person who does the driving. He is the person who does the cooking. This tracks my personal understanding. So, whatever it can be said for Kayla is another story. But, as to Nick, he's a good father. He takes care of his kids, and they seem to be thriving despite whatever problems he has. So, there's that. And no one can take that away from him. So, fair enough. The kids and I are not only members who benefited from his generous heart. Several of my siblings, other family members, friends, and church acquaintances have all been helped financially without hesitation, without demand for repayment. He's used his online presence to help other people raise money that was needed in their lives for problems. His heart shines through in those times. I know my husband's made mistakes and broke the law. Also, you did, incidentally. You just got didn't have to plead guilty, but you also broke the law. But he was just that, a mistake. Please give him the opportunity to show you his integrity. He's a good man. He fights for freedom and free speech, and that bothers some people. They're trying to take away his voice. Please don't let them. Thank you for taking the time to read my letter. Sincerely, Kayla Rekieta. Well, that was exciting and fun. So we'll see what the court does about it. I believe his sentencing is scheduled for tomorrow. And I would imagine that the court's going to land somewhere in the middle if I had to guess. So my best guess is still like 2 to 3 years, probably no jail time, but probably not the 5 that the pre-sentencing report is recommending. But, then again, to be also fair on the other end of the equation, Nick has effed around a little bit on this, as we're aware, and said things online that probably are known to some degree. And so I think that, if you had to say, what are the odds of him getting the better end of the 5 years, it would have to be due to him effing around and finding out. So while a sentence based on the pure facts of the case, I would suggest probably like 1 or 2 years, maybe 3 for probation without any jail time. Based on Nick's exciting extracurricular statements, at least in that and other things with him perhaps being less than him doing some frivolous things on the docket relating to some of his legal filings. It might be towards the higher end, but only time will tell. We will see. All right, so let's see what your super chats looked like during this contribution. And thank you, by the way, for the 1,233 of you who are here. Just a friendly reminder that starting on Tuesday, we will be covering the Karen Read trial, which is fun and exciting. It was fun and exciting the first time, and you should join. It's going to be a lot of fun. $5 from Jackson Kai. My brother was younger when he didn't take a deferred because his lawyer said everyone always reoffends. He's been clean 20 years and regretted forever. Yeah, I mean, you should probably always try to take the deferred, but to the lawyer's credit, probation is really hard. Probation is a pain in the ass. So actually complying is really, really hard. But yeah, I mean, you should have taken the deferral. You should have tried. But he's regretted it. I understand. His lawyer, I think, gave him bad advice. Although it depends exactly what his lawyer said. If he's like, most people reoffend, it's really hard to comply with probation because it's very exacting. It can be very demanding. It can be a pain in the ass. So, I mean, I've known of people, for example, who will not take probation because they just rather finish like their sentence. And in some cases, it can be the rational choice. Like they'd rather just do the extra 3 years in prison rather than take probation. And depending on the circumstances, that can be a rational choice. So it's slightly more complex than perhaps you're letting on, but I appreciate that in your brother's situation, it screwed him, and I'm sorry for that. YSL Kells gifted 5 gift memberships. Elf Pura Eva has been a member for 2 months. $2 from Pin King 554 said you could write an email letter, and JPC has been a member for 17 months. And I'll take a look at some of your other super chats or some of your other comments. Castro says, my mom did that all more, worked full time with a 2-hour commute each way. Yeah. Yeah, Nick got his wife off and mistress in every possible sense. He certainly did. Two to 3 years for possession, for probation? For probation, not for a sentence. For probation. Yeah, that would have been my expectation. Like 1 to 3 years for probation for possession. Yeah, something like that would have been my expectation. Yeah. Good morning, Al Dente. And Alabama Rose just sponsored, really? Just now? Oh, no, you've been a member for 32 months. Sorry, I didn't see the other message. All right, cool. All right. And let's see if there's anything else in chat I want to respond to. Someone was saying 2 to 3 years in jail. Yeah, no, that's unlikely for a first-time offense probation. Yeah, I wouldn't have expected any jail time on this deal. So the fact that state is even recommending 30 days is more than I expected. And I said that already. So yeah, 2 to 3 years on a first-time probation, on a first-time offense? No. Yeah, no. That's unlikely. Someone said, what about the hacking case? Unclear where that is in terms of that. So some of you who are unfamiliar, there has been a suggestion that there was unauthorized computer use by Nick relating to accessing emails he wasn't allowed to access or other things relating to that. I don't know where that case is in terms of its progress, but that is a separate case for another day, right? So there is potentially a looming case in the distance. As to whether or not, there will ever be an indictment or charges relating to that case, who can say? I don't know. I don't know, and you don't really know the full facts of the case. There's just been a suggestion relating to it that he improperly accessed emails or improperly accessed other accounts he wasn't allowed to access. In terms of what the evidence looks like, in terms of anything else, I don't know. So yeah, but that's another case for another day. And if an indictment on that comes down, then we are probably looking at some sort of prison time relating to that, because those offenses can be quite the pain in the ass, depending again on exactly what he's charged with. But yeah, if that happens, prison time is a much more realistic possibility. But again, we don't know the facts. We don't know the facts. We just know that there's rumors. And I don't want to represent facts that I don't know, because that would be irresponsible. So, until there's a charge, we don't know. We don't even know if he did anything at all. We just simply don't have any information. And if he did something, whether or not it was illegal, we still don't know. So we don't. And if he did something and it was illegal, if there's enough evidence to charge him, we don't know anything. So yeah, we just don't know. Am I going to follow Koberger? Yes, I will follow Koberger. The case looks even thinner than I thought it was. At this point, I don't know how in Koberger they're getting to probable cause. I don't even know how they're getting to probable cause. That's how bad the Koberger case is going right now. Because if I understood what they were saying at the last hearing correctly, and I'd like to think I did, but if I understood what they were saying, the so-called touch DNA, the DNA that's on the knife sheath, right? This is like their big piece of evidence. So there was the knife sheath that was left behind, apparently. supposedly the knife that did the murders. The knife sheath was left behind, right? It was found like under one of the victims, like under their body, like in the bed or something, right? And so this is presumably the knife sheath that was involved in the knife. And people have been talking about touch DNA, like Kohberger's touch DNA was left on the knife. But if I understood what the state said correctly, and I'd like to think I did, their own lab said it was 25 times less likely that it was Kohberger versus a random member of the population. It was 25-1 against. 25-1 in favor still would be nothing. So even if I understood it the wrong way around, it still wouldn't be nothing. It still wouldn't be anything. Because if it was 25-1, if it was 25-1 in favor, that would mean that in a room of 25 people, it would be most likely to be him if it was 25-1 in favor. That's shit, right? In a room of 25 people, you go into a diner, there's 25 people in there. And it's like, of the 25 people in the room, it's most likely to be you. That's shit. But it's actually worse than that. It's 25-1 against. So if I understood it correctly, that would mean in a room of 25 people, he would be the least likely person in the room to be it. It would be more likely in a room of 25 random people that it would be one of the other people versus him. In a room of 25, he'd be the least likely person in the room to be the DNA. So the DNA evidence is shit, and it's kind of shit either way, because 25-1 in favor is shit. And 25-1 against is especially shit. So at this point, I don't even know how they're getting to probable cause. I don't even know how they're getting to I don't even know how they're getting to their prima facie. Because what evidence is tying Kohberger to the scene? I don't know. And then they're like, okay, we have his car on camera. And then we got into it in the last hearing. It's like, we have his car on camera. And it's like, oh, when we said we had his car on camera, what we meant was we thought it was what did they say? A 1991 to 1996 Hyundai Elantra. We were able to narrow it down to these 6 model years. Holy shit. Holy shit. It's not his car. It's a Hyundai Elantra of his model year. No, it's one of these 6 model years. Hope you like that. That's as good as we were able to get. Holy shit. That's our evidence, right? Oh, we have cell phone log. We have cell phone putting him in the area. Oh, the cell phone logs are shit because they don't put him, they aren't precise enough. Right? They aren't precise enough to put him to time and place. He was vaguely in the area. Oh, also, maybe he turned off his phone. What the hell? Also, like, we weren't able to find any blood in his car from the victims. What? So it's like, at this point, I'm literally down to, what is your prima facie? What is your prima facie case that he did it? I don't know. I don't know what even your prima facie is. How are you getting to tying him to the thing? I don't know. The case is shit. It's shit. It's shit. It's totally shit. It's holy shit. It's completely shit. It's whole shit. That was the DNA from the fingernail clippings of one of the victims, not the DNA from the knife. Oh, okay. Maybe I misunderstood what it was. Although even then, that's like, okay, so maybe I misunderstood what the DNA was from, what they were talking about. Okay, fair enough. If I misunderstood what I was talking about, then, fair enough. So what is the DNA? Do we have any numbers for the DNA for the knife sheath? Do you know what that number is? I'm willing to retract my rant based on better facts. Do we have any representations from the government relating to the knife sheath? Yeah, there were cell phones turned off as well. Yeah. Can I explain my beef with Nick? I don't know anything. I don't know that I'd necessarily have a beef with Nick, but Nick texted me and said we weren't friends anymore. So we're not friends anymore. And so that's the end of that story. I don't know what more to say than that. It matched. Do you know what numbers of match? Do they have any sort of numbers relating to it? For the knife sheath? I should talk with Andrea about it. Andrea is smart. Andrea is a smart cookie. She's the most underrated person on LawTube. She's smarter than me. So I respect Andrea. Yeah. So we're saying that the witness identified him. Well, we don't have any witnesses that. Well, we have him like at the house at a different time, but I don't know if that was contemporaneous. I have to remember when he was spotted at the house. Maybe that's enough. Although even then, I don't remember that she identified him. As memory serves, and I'm going back in my mind, the eyewitness who spotted someone outside on the porch, I don't believe she identified it was him. I believe she didn't have an. I believe, as memory serves, her identification was just of a male, like in a hoodie and stuff. I don't think she identified it as him, but I could be mistaken from my memory. Yeah, so we're not sure. Yeah, so you're not sure. So yeah, if the knife sheath DNA is a sufficiently reliable match to Koberger, then I think that's enough for prima facie. I'm still not convinced it's enough to convict, but it's enough for prima facie. So if the touch DNA on the knife sheath is sufficiently reliable, and isn't like a shit number, if it's like, if it's a number of any, 1 in a million, let's say, then if it's at least 1 in a million, then I would say that, that's enough for prima facie. I don't think it's enough to convict, but I'll give them the prima facie based on that. So I'll concede the prima facie case if they have touch DNA. That's 1 of a million. Now, that being the case, however, I have more broader problems with touch DNA. I don't think that touch DNA is necessarily as reliable as other forms of DNA. And also, I just don't think it's enough in and of itself to pin it on Koberger. It's enough to suspect him. But personally, I want a little bit more for the quadruple knife murder before I'm about to convict a guy and sentence him to death. But maybe that's just me. Maybe it's just me. The touch DNA, even assuming it's a 1 to a million match for Koberger, is not enough to get me over the finish line. But maybe it's just me. I want a little bit more for my quadruple knife murder homicide death penalty case. Just saying. But it's enough for the prima facie. Yeah, the state wanted to include the fingernails inconclusive where this defense showed it to be exclusive. Yeah, I understood that issue. I just thought it was related to touch DNA. I understood the issue because the issue is if it's less than 1 over 100 either way, by definition, it's considered inconclusive. That's the way they use the labels. But yeah, I understand like technically it's inconclusive, but it suggests against. But so I understood that issue. Probation is not hard. Probation can be exceptionally hard. I don't know if you have personal experience from probation, but probation can be quite exceptionally hard. It can be very exacting. It can be a pain in the ass. So maybe your experience with probation was less exacting, but it can be a real pain in the ass. Especially if your probation officer is a hard ass. It can be a pain in the ass. Yeah, the survivor said she didn't remember and couldn't identify, just bushy eyebrows. Yeah, that's what I remembered. Yeah, that's why I remember. It's like I didn't think the eyewitness identification was that good. Yeah, that sounds vaguely correct. The DNA sheath was conclusive. That's the one they matched familial DNA. And touch DNA is too easily transferred as well. Yeah, so touch DNA is too easily transferred. I don't think it's particularly reliable versus other kinds of DNA. And even if it were reliable, I still don't think it's enough for the quadruple knife murder homicide with the death penalty. So even if you could tell me for an absolute certainty that that's Koberger's DNA on the knife sheath, and even if you could tell me he touched the knife sheath personally, I'm still not convinced that it's enough for the quadruple knife murder homicide with the death penalty. maybe it's just me. Maybe I just want a little bit more. Maybe I just want a little bit more before I'm beyond a reasonable doubt. Like, yeah, he's the one with the quadruple knife murder death penalty. Maybe I just want a little bit more evidence, even assuming that he personally touched the knife sheath, and it is, even assuming it's his knife sheath. Maybe I just want a little bit more for the quadruple knife murder homicide with the death penalty. Maybe it's just me. Maybe it's just me. I just don't think it's quite enough. But that could be just me. Yeah, didn't they get the familial DNA from the trash can? They certainly did. Yes, that's how they did the familial match. But no problem there. Yeah, no problem there. Koberger can't move to suppress. He doesn't have a Fourth Amendment interest in the trash can. So that's not a problem. Yeah, Andrea Burkhardt is a fantastic lawyer. She always does her research. She's methodical in her research. She's incredibly smart. I respect her a lot. Yeah, his Amazon order sheet, I don't know, is necessarily going to get me there. The evidence feels a little thin. The fact that they weren't able to find apparently any blood from the victims in his car continues to amaze me. There's rumors that he like cleaned his car very thoroughly with like Q-tips and stuff, but I don't know if that's true, and I don't know if there's any witness who will say that. But if that's true, if we have evidence of like really methodically cleaning his car like in a short term after the murder, that would be suggestive. But the fact they couldn't find any of the victims' blood in his car continues to amaze me. But that's apparently where we're at. Have I had to buy any new clothes? Not yet. Yeah. Most jurors don't need more, they'll convict. Well, that might be true. That might be true, although I'd like to think that a lot of jurors take the death penalty pretty seriously. So I hope the state has a lot more than that. At this time, it just feels a little too circumstantial for my taste. But then again, the state may have a lot more than we don't know, right? They're not necessarily making their entire case public. So to be fair to the state, there may be more evidence than has been let on at this point. So perhaps they have better evidence than has currently been suggested, or perhaps when they actually lay everything out and put everything together, perhaps it'll be a more compelling case than it currently seems. So I mean, a lot of things could happen between now and then. My gut impression right now is that it's a weak case. But could be there's things we don't know. It could be that when you actually put everything together, maybe it's a more compelling case. But at the moment, I'm like, I need a lot more. I need more things. If you could find the victim's blood in the car, that'd be really helpful. That'd go a long way. But apparently, we can't find it. What would happen if the United States Supreme Court ruled that the United States of America Congress doesn't have the authority to make and pass laws? What kind of strange hypothetical is that? What kind of stupid question is that? Like at all? I don't understand. Although at that point it would be a constitutional crisis, to be honest. So like if your question is what happened, if your question is with the Supreme Court made a ruling that was so batshit crazy, like that it completely defied a blatant part of the Constitution is basically your question, right? So I'll answer your question. Suppose the Supreme Court said that Congress doesn't have authority to pass any laws. What then? My answer to your question at that point is we're in a constitutional crisis. Now that constitutional crisis is being started by the judiciary. So if your point is, can the judicial branch also create a constitutional crisis? Yes. And also Congress could theoretically create a constitutional crisis. They all have the power to create a constitutional crisis. So Congress could do something that's so wildly batshit out of pocket that, it creates a constitutional crisis. The president can create a constitutional crisis. The Supreme Court can create a constitutional crisis. They all have the power to create a constitutional crisis. So I don't know if that's the answer you're looking for, but that's the answer, right? This is the same thing that people were saying in the chat the other day. It's like, what if the Supreme Court ordered the president to drop a nuclear bomb? Would the president be empowered to defy the order then? And I'm like, well, first of all, they'd never do that. The courts have never said anything even remotely close to anything like that. But if they did do that, we're in a constitutional crisis. I don't like constitutional crises. They're not good. So I don't know what point people think they're trying to make, but yes, the judiciary can do unconstitutional things. Yes, the judiciary can do things that create constitutional crises. I'm not quite sure what point people think they're trying to make, but you noted, And the Constitution is good, crisis is bad. Yeah, exactly so. He had 6 weeks to clean the car. Yeah, but I'd like positive evidence that happened, and ideally happened closer to the time of the murder would be nice. So that you can't use the absence of evidence against him, right? So the fact that he had 6 weeks to clean the car means shit to me, with all due respect, because it's the government's burden. It's the government's burden, right? The government has to explain, to my satisfaction, the reason the DNA isn't there. The defense doesn't have to prove jack shit, right? So, look, with the quadruple knife murder, I'd expect there to be a lot of blood, and I expect some of that blood to get transferred into the car. That's pretty reasonable, right? If you're stabbing the people, especially in a hurried manner, because the time frame was relatively short, right? This was a relatively quick stabbing. It wasn't methodical in the actual execution. It might have been methodical in the planning, but it wasn't methodical in the execution, right? So you'd expect the relatively fast-paced quadruple knife murder to involve quite a lot of blood, and therefore when he got into his car, you'd expect that blood to be transferred. Now you might say, okay, well maybe he wore like a bunny suit. Maybe he did plastic sheeting in his car. Maybe he cleaned his car really thoroughly. I'm like, yes, but you're speculating, and you're speculating against the defendant. And I'm not going to let you do that, right? It's up to the government to prove it, right? It's up to the government to show those things to be true. Could those things be true? Sure. But the government is the one that has to convince me beyond a reasonable doubt. The defense doesn't have to prove anything. So if the government has evidence that, he was cleaning his car methodically, if they have an eyewitness that says, the day after the murder or 2 days after the murder, I saw Brian Koberger, cleaning his car with Q-tips and all, that would be great. I'd accept that evidence. That'd be fantastic. And that would be evidence that would get me a lot closer to a conviction. That'd be fantastic. But if there's he could have cleaned his car, that does jack shit for me. That does zero for me. He could have done it. He could have put everything in plastic. He could have put on a bunny suit. He could have, blah, 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 blah. Well, unless you have evidence he did any of those things, go away. Unless you have evidence of those things, go away. That's what I'm saying, right? The state has to prove it. He doesn't have to prove anything. They quit looking for anyone else that might have done the murders. That also does jack all for me. Yeah, I mean, I hate to point this out again, but even if he's the most probable suspect, that isn't enough. It's not enough for me. This isn't, guess who. We're not eliminating everyone on the board and whoever's left is the guilty guy. That is not how this works. It's not how it's supposed to work anyway. It's not how it's supposed to work. It's not like, let's eliminate everyone else and therefore this must be the guy. That is not how this works. They have to convince me he's the guy beyond a reasonable doubt. I don't care if they don't have any other suspects. I don't care if he's the only viable suspect. I don't care if he's the only possible suspect. Like, they have to prove it. They have to prove that he did it. It's on them. It's their burden. Right? I'm sorry that you have no other suspects. I'm sorry that no other suspect is a better suspect than Bryan Kohberger. I'm sorry he's your best suspect. Not good enough. Not good enough. Prove to me that he did it beyond a reasonable doubt. At the moment, I have doubts. Maybe those doubts can be satisfied. Maybe the state can prove it. Maybe they have more evidence than they're letting on. Maybe the picture when they're doing it is better than it has. At the moment, I'm like, no. Maybe it'll be yes later. I'm not beyond being convinced. I don't feel like I have enough evidence at this time to say like Bryan Kohberger should be found not guilty. I'm not saying that. I'm not saying I don't have enough evidence that I think that he should be found not guilty. I'm not saying that. All I'm saying is at this time, at least in my opinion, based on what's publicly known, the case is much thinner than I'd like it to be. And I'd like more, please. Please, sir, can I have some more? Please, sir, can I have some more? But, you know, maybe they have more. Maybe when they lay everything out, it's a better case than it looks at first blush. We'll see. But I'd like a little bit more for the quadruple knife murder with the stabbings and the death penalty, please, if you don't mind. Please, government, could you provide me some more? I'd really appreciate it. Oh, there's a Karen Reed motion decision that just dropped. Exciting. Let's do that. Oh, it's not very long. Ruling on Commonwealth's motion to compel reciprocal discovery. Defense required to provide discovery. Defendants must disclose to Commonwealth any oral representation. They're still doing the ARCA thing, man. Come on. Come on. I mean, this judge, I swear to God. Yeah, you went to the trial? That's a perfectly reasonable thing. That's a perfectly reasonable response. I'll wait to the trial. That's a fantastic, reasonable response. I approve. I approve. You don't want to judge things based on a half-assed picture. You don't want to draw a conclusion based on a half-assed picture. I approve. This is great, right? It's like, we don't know it. We don't have enough information yet to draw a conclusion. Sometimes we do. We don't have it here. For example, in the Kyle Rittenhouse case, I felt like we could draw enough. We had enough to draw the conclusion. The reason I felt like we had enough is because the information, the formal charging document, read like a defense document, right? It basically provided enough information in the charging document to be like, oh, he's not guilty. And it's like, I don't need to know anything more. I don't need to know anything more. When you are writing the formal charging document, you are got to be putting forward your best possible case, right? I mean, it's not going to get any better than that. And when your own best possible case basically defeats yourself, I'm like, yeah, I'm done. But, you know, not every case is like that. Most cases aren't like that. Most cases are some zone of uncertainty. Nina Stanek for 10 CHF. Which is Swiss, I believe. Yeah. Sorry for a long question regarding Karen Reed and Turtle Boy. If the Commonwealth's only goal was to keep Turtle Boy out of the courtroom, could they grant him immunity? Yes, they could. And I don't know. I thought that's what they were trying to do. They could grant him use and derivative use immunity and it would solve their problem. So if their only reason to keep him off the stand, if their only reason is we don't want him in the courtroom, if that's their real reason, is like we just don't want him in the courtroom because we don't want him there for whatever reason, if that's their real reason, then the state can fix this problem. They can just give him use and derivative use immunity, and then they never call him to the stand, and then there's no problem, right? Use and derivative use immunity only prevents you from using anything he said on the stand anyway. So it's like, it doesn't prevent you from prosecuting him. You can still prosecute him. You just can't use anything he said on the stand against him or anything that derives from that, you know? So it's like, you could just do that. And if you don't even want that much, you could just like never call him to stand and just give him use and derivative use immunity. So like, I don't know if that's what they're planning on doing, but they could do it. And I don't know why they're not doing it, but that's what we're doing. It's weird, but that's where we're at. Yeah. You disagree with the Rittenhouse verdict? I don't know how you disagree with the Rittenhouse verdict. I don't know how you disagree with that on the facts or law, but some people will never be convinced. No matter what. I guess. Why didn't they do that? I don't know. Yeah, I don't know why they didn't do it. I don't know. I thought, I was trying to figure out why did Hank insist on like Turtle Boy himself saying he wanted to invoke the fifth. Why did he take? I mean, there's two reasons he could have done it. Like that have come to my attention. One reason is that he was hoping Turtle Boy would actually be put on the stand, and that he would take the fifth and he'd get his soundbite for the news. Was one reason. The other reason he was doing it is because for some reason he thought it was a required step in a grant of immunity. And so he was doing it so somehow that would provide a predicate for him granting the immunity. So otherwise I don't know why Hank insisted on it. Or option number 3 is just because he wanted to be a jerk, which I suppose we shouldn't put past option 3. Option 3 is I just want to be a jerk. I just want to make him do it just because I can, just because I'm an asshole. Yeah, option 3 could also be a thing. Looks like I just hit 144K. No, I've been 144K for a while. I'm about 144 and 5 last time I looked. I'm about halfway to 145. But yeah, I've been stuck at this number. This number only rounds to nearest 1,000. So that number behind me is not dead on accurate. It's only accurate to the nearest 1,000. So the actual number is like 144.5 something last time I looked. Do you know who's doing opening arguments? I'm pretty sure it's Alessi doing opening arguments, as memory serves. What else? Oh, and by the way, people are still questioning me on this whole like whether or not I think I might be right, but if I'm wrong on this point, I'm willing to be corrected. But no one's actually like corrected me on this point. Like, can a terrorist be like officially sponsored by the state and still be a terrorist? I don't know if that's possible. It might be possible, but I'm not sure if it's possible. Because if you had an official state terrorist, aren't they just a military at that point? And some people said to me, like, what about Al-Qaeda or the Taliban? And the thing there was we didn't recognize their government. So they weren't a government because we didn't recognize their government. So therefore they can't be a military, right? So that's why like the Al-Qaeda example doesn't work, because we didn't recognize the government at all. So they can't be a military because there's no military, there's no government for them to be a military of. So therefore they're terrorists, right? So like, is it possible to have a state-sponsored terrorist? I don't know if that's possible. As opposed to them just being a member of the military, I'm not sure. Yeah, I don't know if that's possible. And if the point there is like, yes, then that means we can choose who is not a government. That's true. So like, that's true. We could change who the government is. So if we wanted to recognize like the gang in El Salvador as being the government, we could do that. But that comes with a whole host of consequences diplomatically and legally. So yeah, could we in principle designate the gang, TDV or whatever their name is, could we in principle designate them as the government? Yes, we can do that. First of all, the current government of El Salvador is going to be really pissed. And second of all, once we do that and recognize them as a government, now they become a military, which great, now they're a military, but that comes with a whole host of protections under law relating to be a member of the military. Because once you're a member of the military, that comes with protections under the Geneva Convention and everything else. So like, it's not a free ride. So like but I'm still not sure whether it's possible to have a government sponsored terrorist. I'm not sure if that's actually possible. So I'm still working on that. So if it's possible to have a government sponsored terrorist, let me know. I'm not sure about that. Yeah, Hamas is not a recognized government. We don't even recognize their country. It's even worse than that, because we don't even recognize the country they want to be a government of. So not only do we not recognize their government, we don't recognize their country. So it's even worse than that. So Hamas is definitely not a government. They're not even a country. Palestine doesn't exist as far as the United States is concerned. So there is no country. So yeah, that's even worse. Yeah. Okay, the United States government recognized Cuba, Iran, North Korea, and Syria as being state sponsors of terrorism. So yes, Iran can be the most obvious. That's an interesting point. That's an interesting point. Fair point. Okay, so you have these governments that are sponsoring terrorism. Interesting. Interesting. That is a good counterpoint. I'll have to think about that. Yeah, because in the case of Iran, for example, you have them potentially funding and arming terrorist organizations that are not considered part of the government of Iran. Interesting. That's an interesting point. Okay, so maybe it is possible to have a government-sponsored terrorist. Interesting. Okay. Okay, that's a fair counter. All right, I'm gonna have to ponder that some more. I might have to modify my thinking on this point. And so then what would that mean as a matter of US law for the purposes of, for example, the Alien Enemies Act or something? So if it were possible to have a government-sponsored terrorist, and the government-sponsored terrorist was doing things in the United States, would that therefore be considered an incursion within the meaning of the Alien Enemies Act? It might be. Yeah, that's a fair point. Yeah. So I might have to modify my interpretation of the Alien Enemies Act. I'm going to have to give that some further thought. Thank you for the super chat. I'm going to have to give that some further thought. Jenks Medic for $10 says, Kurt, let's be honest. Nick's chat is rather crass, but I'll be honest. I miss you two and your chemistry. Enjoyed meeting you. Hope for healing, redemption, earn forgiveness. Fair enough. I appreciate that. Yeah, that's enough of a tangle that some guidance from DOJ might be useful. Yeah, I'm interested in what the DOJ has to say on this issue relating to the legal implications of a state-sponsored terrorist. So assuming it's possible for there to be a state-sponsored terrorist, because we do recognize the government of Iran, so that's not the problem. And we say that Iran itself is funding and supplying the terrorists. That's our position, which then makes it state-sponsored. So that's not the problem. And we say that they're terrorists as opposed to military. So that's not the problem. So then if those entities were, for example, performing actions within the United States, would we therefore say that Iran was committing an incursion within the meaning of the Alien Enemies Act for the purposes of deportation? Probably yes. So yeah, I think I might be wrong. And okay, so then that gets into the issue of how do we deal with that in the case of El Salvador? So I don't know that the US government has I don't know if the US government has said that like TDV is being sponsored by El Salvador. At least today. At least as it's happening contemporaneously. Maybe in the past they did, but of course we're concerned about the present because we're concerned about whether or not El Salvador is currently doing an incursion inside the United States. So in the past, El Salvador might have been sponsoring TDV, but are they today? That's less clear. It's not even clear TDV necessarily exists anymore because our position has been that we wipe them out, right? So if we wipe them out, they can't exist, which means that they can't be sponsoring them because there's nothing to sponsor. So I think that would undermine the US position. So either that they're not sponsoring them today or the fact that they don't exist at all today, I think would undermine the US position relating to the Alien Enemies Act. But it's an interesting question and made me think, and I appreciate thinking. It's fun. Can anyone but Congress invoke the act? Oh, sure. Yeah, no problem. Yeah, the Alien Enemies Act is an act of Congress. It gives the executive power. That's not the problem. Yeah, the president absolutely has the power to invoke the Alien Enemies Act, no problem. What exactly it is more the issue. But it is the president's power, whatever it is. And what that means in terms of uh, the people designated relating to that is another issue. Like, does the power of the president to invoke the act mean that people don't have due process? Well, the answer to that is no. And the Supreme Court just said that last week, right? They already said that. They said that people, even people under the Alien Enemies Act, are still entitled to notice, a hearing, and habeas. And again, those processes can be very cursory. So those processes are not as complete, but they're still entitled to that. So even though the president has the power to invoke it, and also challenging the constitutionality of it as well, incidentally. So like they can still challenge it, they're just challenging it through a different mechanism. So like exactly what does it mean? And does it apply to these people at all is still a bit of an open question. Right? That question is still not resolved. Does it apply to these people? It's still unresolved. So that still has to work its way through the thing. But yeah, very interesting. Can the U.S. president pardon himself? I think the answer is yes. Does it require a declaration of war? No. The way the act is written also applies to insurrections and incursions. So it doesn't require a declaration of war. No, an incursion will be sufficient. And an incursion is at least any military action, even if it's not a declared war. It says at least that much. I don't think that's the problem. Would be a more efficient way of deporting alien criminal gangs? Well, if they're aliens, if they're illegal aliens, just deport them for that reason would be probably the easiest way to do it. It's like, why complicate this? I mean, the reason you were trying to do it is trying to get an express pass, but the Supreme Court kind of denied you your express pass. So probably the easiest way is just to deport them for being illegal aliens. Like, why complicate it? Why prove more than you have to prove? They're just here illegally. Who cares whether they're a gang member or not? If the reason you want to deport them is because they're a gang member, then that's just because you prioritize that. You're allowed to prioritize. So you want to prioritize people that are members of gangs. Okay. But just deport, the reason you're deporting them is just because they're illegal aliens. Just do that. It's not that hard. They're here illegally. Deport them for that reason. Call it a day. Yeah, I mean, why overcomplicate this? The reason they were trying to is to try to avoid the due process, but they can't do that anymore. So just do the thing. I mean, that'd be my suggestion. Can a president declare war? No. Terrorist and government are vastly different concepts. Pirates were state sponsored. Well, I'm not sure, strictly speaking, if they'd be considered pirates at that point, but your point is taken. They'd be, what would be the term for it when you have a state sponsored pirate? Is it called a buccaneer, or is it called a privateer? They're not called pirates anymore. I think they're called a privateer. But yeah, privateer. Yeah. Privateer. Yeah, they're not called pirates anymore. We call them pirateers. Yeah. What else? Euphemism? Maybe. Somali had privateers, not pirates. I'm unclear the degree to which the Somali government was officially. I'm unclear if the Somali government was officially using them. So, does the Somali government support it? Then maybe. If they just deport them for being illegal aliens, would that have solved their legal problems? What? I understand your question, but yeah, we can deport illegal aliens. That's easy. They're just here illegally. Just deport them for that reason. Call it a day. Why overcomplicate your life? You know. All right, I'm going to go ahead and sign off for now. I've enjoyed our chat together. So we'll see how this whole thing resolves tomorrow with Nick. We'll see what he actually gets in terms of actual penalty. And then also, of course, the transcript. So I probably won't cover anything tomorrow. I'll probably wait till the transcript comes out, which will probably take a couple days. So I'll try to cover it at some point, probably next week. And or maybe next Saturday. So it might be like a week because I'm going to be busy with Karen Reed, so I might not have time next week. But I'll cover his sentencing at some point, so probably next Saturday, if I had to guess. And we'll cover whatever sentence he does get, and we'll cover the transcript of the hearing, and we'll go from there. That should be fun. All right, guys. I've been Uncivil Law. I hope all's well. Remember to tune in on Tuesday for the Karen Reed stuff. It's going to be a fun time. I've been Uncivil Law. Hope you have a great time. Till later, my friends. Cheers and goodbye.